Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content, and today may be the day I earn your subscription. For today's story, we are covering whether or not the EPA can regulate ozone coming out of commercial trucks. This is the United States Supreme Court from 2001, Whitman versus American Trucking. In this case, they decided to add a law that prevented people or regulated ozone. And the question is the regulation proper? So let's get started with this. These cases pose the following questions. Where the Clean Air Act delegates legislative power to the EPA, whether the administrator can consider costs of implementing and setting air quality standards, and whether the Court of Appeal had jurisdiction to review the interpretation with respect to revising ozone levels. The relevant law, as amended, provides the following. Each pollutant for which air quality criteria has been issued is promulgated. Once it has been promulgated, the administrator must review standards and the criteria on which at 5-year intervals and make such revisions as may be appropriate. So there is a two-step process in terms of regulating air pollutants. There is the regulation to promulgate what air pollution qualities are, and then they must review them every 5 years to keep updating the standards. So that's the standard process for the EPA in terms of administering the Clean Air Act. The relevant law instructs the EPA to set the ambient air qualities with the following goals, the attainment and maintenance of which are requisite to protect the public health, with an adequate margin of safety. Now, were it not for hundreds of pages to the contrary, one would have thought it fairly clear the text does not consider the EPA to consider cost. The language is absolute. It just says, consider what is necessary for public health with a margin of safety. It doesn't say anything about cost factors. The EPA, based on this information about health effects contained in technical criteria documents compiled under the law, is to identify the maximum airborne concentration of a pollutant the public health can tolerate, decrease the concentration to provide an adequate margin of safety, and set the standard at that level. Nowhere are costs to achieving this standard made part of the calculation. We're just looking at it straight from a position of what is prudent for the health. Respondents argue that many more factors than air pollution affect the public health. In particular, economic cost of implementing the stringent standard might produce health losses sufficient to offset health gains, for example, by closing down industries and impoverishing workers and consumers dependent on that industry. So it's like, yeah, maybe there are things other than the air pollution costs or that would influence health, like economic costs that would also influence health. And that might be true as far as it goes, but, not really what the statute has to talk about. Accordingly, to prevail in the present challenge, the respondents must show textual commitment of authority to the EPA to consider costs in setting the standards. And because of the relevant law which provides are the engine that drives nearly all of the Clean Air Act, the textual commitment must be clear. Congress, we held, does not alter fundamental details of regulatory schemes in vague terms. It does not say hide elephants in mouse holes, which is a common expression of it doesn't hide the ball. So this underpinning, this central underpinning of the Clean Air Act, which the Supreme Court is saying is the dominant thing, says basically in so many words, consider how it will influence the public health. Set minimum standards, or maximum standards, I suppose, depending on your point of view, with relevant safety in mind. It doesn't say take into account anything considering safety or anything concerning cost. Cost is not a factor. So that it will cost a lot for industry is not a factor that the relevant law at the time contemplated. The relevant law of the Clean Air Act, the EPA must set ambient air quality standards, the attainment and maintenance of which are judged by the administrator based on criteria and allowing adequate margin of safety that are requisite to the public health. The Court of Appeals held this section, as interpreted by the administrator, does not provide an intelligible principle to guide the EPA's exercise of authority. The EPA, it said, lacked any determinate criteria for drawing lines. It failed to state intelligibly how much is too much, and the Supreme Court says we disagree. Okay, so this is a question about the ability to delegate legislative authority. When Congress cannot delegate legislative authority. So the question is, did it? Did it delegate the ability to legislate? Now, this gets a little bit complicated, but long story short, the courts are very, very hesitant to find it. It doesn't come up very much. It does occasionally happen, but it takes a fair amount. Merely giving the agency the ability to work within defined parameters, as long as the parameters are not too ambiguous, but it's unusual. So the question is here, are these provisions too ambiguous? So we can read that discussion. So in a delegation question, which is legislative delegation, power to delegate legislative authority, the question is whether the statute has delegated legislative power. The text permits no delegation power. So the Supreme Court says, the Constitution says, you can't delegate legislative power. That's true. We've never suggested that an agency can cure unlawful delegation by adopting discretion in limiting construction. So if there is an improper delegation of authority, the agency can't fix it by saying, well, we're going to self-limit. It's like, no, if it's improper, it's improper. You can't do that. We agree with the Solicitor General that the text of the Clean Air Act, at a minimum, requires that for a discrete set of pollutions and based on published air criteria that reflect scientific knowledge, the EPA must establish uniform standards at a level that's requisite to protect health from adverse effects of pollutant in the ambient air. The scope of this discretion, which is different from legislative authority, the discretion is in fact well within the outer limits of the non-delegation precedent. In the history of the court, we found the intelligible principle lacking in only 2 statutes. It hasn't come up a lot. It hasn't come up a lot where it's so unclear that we say, yeah, that's improper. One of which involved literally no guidance for the exercise of discretion, and the other which conferred authority to regulate the entire economy on the basis of fair competition. That's too loose. Too loose. Can't go that far. So, yeah, it is a thing. It's very, very unusual to hit. Incidentally, when the Biden administration was trying to argue the CDC had the authority to do all the things, I was saying in my head, yeah, I think we're triggering that threshold. Lawrence Tribe, apparently, who disagrees with me, was calling me an idiot for thinking that, though. But, yeah, it's like, it doesn't come up very much, but I think we're there. In short, we've almost never felt qualified to second-guess Congress's reading of the permissible degree of policy judgment that can be left to those exercising the law. It's true enough the degree of agency discretion that's acceptable varies according to the scope of the power that Congress has conferred. We therefore reversed the judgment of the Court of Appeals that said that this was an improper delegation of legislative authority. No, this is within the bounds. You have to keep in the breathable air pollutants that are harmful to the health. It's understandable enough that that's not improper. They can regulate within that. That's okay. The final 2 issues that we've reviewed concerns the EPA's authority to implement this revised ozone standard, in which the standards currently exceed maximum levels permitted. On the merits of this issue, this is Chevron. We know Chevron all too well. If a statute resolves the question, then that is the end of the matter. But if it's silent or ambiguous, then we must defer to the reasonable interpretation by the administrator. We cannot agree with the Court of Appeals that the law clearly controls implementation with respect to revised ozone, because we find the statute ambiguous. We conclude that, however, the agency's interpretation goes beyond the limits of what's ambiguous and contradicts what in our view is clear. We therefore hold the policy as unlawful. So, although the particular section was ambiguous, there are other sections that were clear, and in doing what they were trying to do, they were going against those sections. So while one section might have allowed it, other sections did not, and of course, the law has to be understood as a contemporaneous whole. Whatever effect may be afforded gaps in Section 2, as implying some limited applicability, they cannot be thought to render Subpart 2's careful designated restrictions on discretion utterly nullatory once a new standard has been promulgated and the EPA has concluded. The principal distinction between the sections is the latter eliminates regulatory discretion that the former are allowed. While Subpart 1 permits the EPA to establish classifications for non-attainment areas, Subpart 2 classifies areas as a matter of law based on a table. So the EPA has some authority to establish where the law doesn't apply, but not all the authority, because in Subpart 2, there's a table and says basically if these things are true, you have to regulate there. You can designate other areas. So you have the authority to designate areas where it doesn't apply, But your authority to designate areas where it doesn't apply doesn't permit you to designate those areas. The law says it must apply. That would be dumb. According to the EPA, Subpart 2 was simply Congress's approach to implement the standard, and there's no reason the new standard cannot be simultaneously under the law, which would make Part 2 abruptly obsolete, because then the tables disappear. If the EPA has all the authority under table, this is exactly the same kind of argument we're dealing with the CDC, right? If they have all the authority from Part 1, it renders Part 2 irrelevant. Like, you can't do that EPA, you can't do that CDC. No. Subpart 2 was obviously written to govern implementation. Some of those may be included under Part 2 not to take effect, but still, they're relevant when they do. We therefore find that the implementation policy to be unlawful, no, not in the precise respect determined by the Courts of Appeal. After remand, they'll have to, figure out around all that because the proper interpretation of the statute hasn't been followed. Thus, that brings us to the end of the consideration of the case of Whitman versus American Trucking. This was a very complicated issue of regulation of clean air for the Environmental Protection Agency, and we learned a couple things. First of all, we learned that the EPA, much like the CDC, wanted all the power, although there was a section of the law that says you must regulate in these particular ways. Or in the case of the CDC, you can only regulate in these particular ways. And they said, but we want the section that says we can do all the things. And both times the Supreme Court has looked at that and said, no, you can't. You can't interpret the second section out of existence. The first section might say one thing, but the second section also informs it. So in the case of the EPA, you must regulate in these areas. In the case of the CDC, you cannot regulate in these areas because that's what the relevant law requires. Deep concepts. We also learned that when they're putting out guidelines, that cost of implementation is not a factor. They're supposed to just consider what is helpful to the public health, not how much it will cost industry to comply. So, and yeah, their ability to regulate is not indefinite, and it's not indefinite, so it doesn't comprise an improper delegation of authority. They have to regulate the air that's for human health. And there's enough specificity in that to not run the problem. So that was a lot that we learned from this case, and that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.